Good morning, good evening, good afternoon, fellow judges, participants, as well as the general audience. Welcome to Green Law Global Initiative 2026 International Moot Court Competition on Climate Justice and Environmental Governance. This year's theme is Climate Change, Transboundary Apparel Harm, and Circular Economy. This is the third session, which will feature Kisii University from Kenya, representing the state of Tanzania, and Lead City University from Nigeria, representing the interested party, SECA. With that, I'd like to welcome you to this session, and may I hand over the session to Court Assistant Naomi to take over. Naomi?
Okay, so good evening, everyone. My name is Naomi Birundu, and I'm the court assistant for this session. Welcome to the third preliminary round of the Green Law Global Initiative Climate Justice International Moot Court Competition 2026. So the matter before this honorable court is between Kisii University, Kenya, representing Tanzania, versus Lead City University, Nigeria, representing SECA. The honorable bench for this session consists of Judge Helen Omondi, who will be our presiding judge for today, Judge Antoinette Ogange, and Judge Matthew Emukule. I now respectfully invite the honorable judges to take the bench.
Sorry, go on.
Okay, it's okay. The court is now in session. I respectfully hand over the proceedings to the honorable presiding judge.
Thank you very much, Naomi, and greetings to all those that are present. We shall proceed. My apologies that my camera has totally disobeyed every instruction that I have attempted to, but trust that it will sort itself out as we proceed. So,
Judge, if I may, respectfully, before you proceed, Judge,
yes.
May I kindly request the participants to switch on their cameras? That is one of the crucial rules of the virtual courtroom. Kindly switch on your cameras, participants, and the judges who can switch on their cameras, including Antoinette, switch on your cameras, and then we may proceed. Back to you, presiding judge. Thank you for that indulgence.
Thank you very much. So we shall take off, and you may call the first presenting side, court assistant.
Naomi, can you invite the first side?
No, Naomi, you are muted. She's muted.
Oh, sorry for that. I forgot. So the first side will be Kisii University, Kenya, representing Tanzania.
Kindly please tell them of their time.
Okay, just to clarify on the time, each side will be having 30 minutes for their submissions and 10 minutes for the rebuttals. I will remind you when you have 5 minutes left and a minute, and when your time is up.
Counsel for Tanzania, you may proceed.
If it pleases the courts, I would like to begin. My name is Ms. Angelina Mune, the first counsel for the applicants. Appearing alongside me is Ms. Shanice Kadenyeka, the second counsel. Honorable members of the courts, we are going to divide our time as follows. I will use the first 16 minutes to dispense on the preliminary issues and issues 1, 2, and 3, while the second counsel will use the subsequent 12 minutes to dispense on issues 4, 5, and 6 and submit our prayers. Therefore, we intend to reserve the remaining 2 minutes for rebuttal. Honorable members of the bench, the applicants submit that these honorable courts has the requisite jurisdiction to hear and determine the matter at hand, pursuant to Article 65 of the International Court of Justice Statute, which provides that these courts may give an advisory opinion on any legal issue at the request of any duly authorized party, and that is pursuant to Article 96 of the Charter of the United Nations, which provides that the United Nations General Assembly and the Security Council are duly authorized to appear before the courts. Honorable members of the bench, in this particular context of the Republic of Azania, pursuant to page 5 of the fact sheet, it is the United Nations, apologies for that, it is the United Nations General Assembly that adopted a resolution and submitted it to the International Court of Justice, requesting it to render an advisory opinion. On to the issue of admissibility, the applicant submits that the matter at hand is admissible before this honorable court pursuant to an advisory opinion given by these courts in the matter of the interpretation of the agreement between the World Health Organization and Egypt. It's a 1980 issue whereby the court held that the ICJ can only give an advisory opinion in a matter which involves a legal question. Honorable members of the bench, allow the respondents to confer apologies for the issues with the camera, but yeah, it's okay with your permission, honorable members of the bench. Now, my lords and my ladies, allow me to invite you to picture with me the following scenario, whereby you are seated in your sitting room following the news, and a woman who is among the 2.5 people who engage in second-hand businesses, for the second-hand apparel businesses, cries out to the government for help while she's drowning in her house filled with water after floods, asking the government to help her. And also another scenario where in the coastal communities of the Republic, we have an old man who is satisfied after a day's good catch of fish and is also happy that his daughter is doing her internship in a nearby hotel after just recently graduating from university. Honorable members of these courts, it is the applicant's submission that the latter is the kind of future that the government of Tanzania wants for its citizens and not the latter. Honorable members of the bench, the applicants would like to move on to issue 3, whereby we aver that the measures adopted pursuant to the ICJ advisory opinion do indeed justify limitations on international trade under environmental and human rights obligations. Honorable members of the bench, the fact sheets, pursuant to the fact sheet, there are various obligations. There are various measures that have been put in place, which include extended producer responsibility for apparel importers and minimum quality thresholds prohibiting imports of unsellable garments. These measures are in the TWCCEA Act. Honorable members of the bench, there are limitations. These measures have been put in place in response to the limitations which are found in Article 20 of the General Agreement on Trade and Tariffs, whereby Article 20B provides that these limitations can be put in place whereby it is necessary to protect human and plant life and health. And even in Article 20G, which provides that these limitations can be put in place in issues relating to the conservation of exhaustible natural resources. Honorable members of the bench, it is evident that the failure to do something to regulate the imports would continue to adversely affect the already vulnerable and burdened state of Azania, that is pursuant to Part A of the fact sheet, page 2. Honorable members of the bench, the failure to regulate these imports will cause the chain of causation of climate change, which we can see in Part B, that the excessiveness of these second-hand this second-hand apparel has caused climate change issues with them dominating informal landfills and necessitating them to be banned informally, releasing toxic emissions, which thereby exacerbates climate change issues like flooding. Honorable members of the bench, it is our submission that the purpose of including Article 20G was to ensure that the commitments under the general agreements of trade and tariffs does not hinder the pursuit of policies aimed at the conservation of exhaustive natural resources, and the measures ought to be primarily aimed at such conservation. That was the holding in the case of herring and salmon. It's a Canadian case in paragraph 4.6. Honorable members of the bench, I'd like to move on to the second limitation, which is found in the Chapeau article 20, the introducing part, which is the principle of non-discrimination. It provides that whereby limitations under Article 20G and B have been put in place, these limitations should ensure that these limitations should be put in place not as discriminatory limitations, but there has to be a real...
Apologies. Matilda, kindly mute and switch off your video. Proceed, Councillor.
Mr. President. Yeah, so there has to be a real imminent danger on environmental law. And in the Republic of Azania, we see that Azania is only doing it for a legitimate purpose for environmental concerns. And it's doing it based of empirical evidence in Part B, whereby government commissioned reports showed that 35% to 45% of the imports arrive as in unsellable conditions, therefore perpetuating the chain of climate change. Honorable members of the bench, I'd like to move on to the third limitation, and that is the necessity test, which was canvassed in the US gambling case between Antigua and Barbuda, whereby it was stated that a measure is necessary if there is no other available alternative. In the case of Azania, this measure of the measures that were put in place were the measures of last resort after other measures like landfills had been exhausted. And Azania, being one of the world's largest importers of second-hand apparel, and it also being a middle-class income country, does not have or is not able to afford the requisite measures of disposing of with this waste. As you can see that their landfills are already filled, resorting to disposing waste in open dump sites. Honorable members of the bench, I will conclude on this issue with the proportionality test, which the applicants submit before this honorable court, that it cannot exist independent of the necessity test, as we submit that the Republic of Azania puts restrictions or rather measures that were proportional to the objective that was supposed to be met, and that is environmental protection. And we also see a direct link between the imposition of those restrictions and the reduction of environmental harm. My lords and my ladies, I'd like to conclude with the Locus Classicus case of the retreaded tires. It's a Brazilian case which has more or less similar facts with the case at hand, only that in the Brazilian case, the issue at hand was not second-hand apparel, but rather was refurbished tires. Honorable members of the bench, I would like to proceed to the first issue, whereby the applicant submits that the ICJ advisory opinion affirms a positive obligation on states to regulate transboundary value chains, including the second-hand apparel trade that contributes to climate change and environmental degradation. Honorable members of the bench, positive obligations are obligations that require actors to take active steps to do something and not merely refrain from doing it. I will tackle this issue in two limbs. I will first of all state the obligations under law and also show how these ensure how these how the transboundary waste ensure the necessity of the regulation of the transboundary waste. Honorable members of the bench, we have the United Nations Framework Convention on Climate Change, whereby in Article 3 puts in place the precautionary principle whereby states ought to put precautionary measures to anticipate, prevent, and minimize the causes of climate change. In Article 4, paragraph C, it also states that states should promote the application, practices, and processes of practices, technology, and purposes that control and reduce or prevent anthropogenic emissions of toxic gases like carbon dioxide, nitrous oxide, and methane. The UNFCCC also puts in place the adaptation obligation to states. I will move on to the Paris Agreement, whereby in Article 4, paragraph 2, puts in place a duty to states to mitigate climate change impacts. It also mandates states to take active action to conserve and enhance appropriate sinks and reservoirs of greenhouse gases. Honorable members of the bench, the applicant relies on the binding, in the case of the applicant relies on customary law, and more particularly in the case of military and paramilitary activities in and around Nicaragua, where it was stated that a party may be bound by particular treaty provisions, even when they are not party to those treaties, as long as those provisions fall under international customary law. And the honorable members of these courts, the previous submissions on the Paris Agreement and the UNFCCC fall under some principles of international customary law, and some of these principles are the prevention principle, or rather the no harm rule, which has been canvassed by these courts in the 1996 advisory opinion on the legality of the threat or use of nuclear weapons, whereby it stated that there exists a general obligation for states to ensure that activities within their jurisdiction and control respect the environment of other states. This, in application to the states of Tanzania, shows that this principle provides that in the contemporary application that fast fashion in developing countries should not be a catalyst to transboundary pollution in the name of second-hand apparel exports to developing countries, which have contributed negligibly to climate change, just like Tanzania pursuant to Part 8 of the fact sheets. Honorable members of the courts, I would like to move on to the polluter pays principle, which also falls under customary international law, which provides that the polluter ought to bear the burden of the pollution that they have caused. Honorable members of the courts, it is the applicant's submissions that the no harm rule just doesn't prohibit harm, but also requires states to actively take appropriate and necessary measures to prevent, control, and reduce significant transboundary environmental risks. I would like to move on to the principle of common but differentiated responsibilities, whereby all actors have a duty, they have a common duty to regulate, or rather to combat climate change, but in different capacities, and most especially where there are gaps in development, with developing countries having had contributed more historically to climate change, and with developing countries which have contributed negligibly, having to bear most of the cost. Honorable members of these courts, Why is there a need to regulate transboundary value chains, including second-hand apparel trade that contribute to climate change? The need is evident in the case of Tanzania, but due to the failure to do the regulation, there is over-reliance on second-hand apparel trade, which at the end of the day will need to be disposed. And as previously submitted, the Republic of Tanzania is a growing state which may not have the capacity to dispose this waste as required. Honorable members of the bench, it is also evident that the informal banning and disposal of this apparel waste causes climate change pursuant to page 3 of the fact sheet, where we see that the effects of this climate change have caused waterborne diseases disproportionately affecting children. It is also a submission that the breach of the due diligence and the no harm principle, apologies. Honorable members of the bench, we'd like to submit that yes, it is indeed true that this ICJ opinion of 2025 affirms a positive obligations on states to regulate transboundary value chains, including second-hand apparel imports. With the permission of the bench, I would like to proceed to issue 2, which is my last issue before I usher in the core council, whereby the applicants averse that Tanzania's failure prior to the TWCCEA to regulate second-hand apparel imports does not constitute a breach of the due diligence obligations under international law. We rely on the case of Netherlands versus the USA, which is the case of, also known as the case of the island of the Palmas, in page 8, which states that due diligence lies at the nexus between responsibility of states as members of the international community and the sovereign right of states to act within their territory in accordance to international law. Honorable members of the bench, due diligence is a duty of conduct and not results. That was the holding in the case of Bosnia and Herzegovina versus Serbia and Montenegro. In this particular case of Tanzania did act in a way, Tanzania's conduct as seen in part A, that is page 2 of the fact sheet in the first paragraph. It is seen that Tanzania it is seen that Tanzania has contributed negligibly previously to climate change, and therefore did not foresee a risk of climate change happening as a result of these imports. And we see that this conduct, and we see that, and therefore there was no need for prior action. We see that the conduct of Tanzania developed with time in progressive realization, whereby the government did audits on the relationship between this apparel import, on these second-hand apparel imports and climate change. After doing these audits, it then acted upon them in response to the advisory opinion of these courts, and imposed proportionate regulatory measures, and that is the TWCCEA. Honorable members of the bench, the case of SERAC versus Nigeria states that African states, in the case of SERAC versus Nigeria, the African Commission recognized that socioeconomic rights impose positive obligations on states. Further, the United Nations Framework on Climate Change, the United Nations Framework Convention on Climate Change, in Article 4F, provides that states should balance climate change considerations and economic development, as was the case in the pulp mills case. Honorable members of the bench, it is our submission that the state of Tanzania was forced to prioritize economic rights to prioritize first economic rights, under these obligations in the UNFCCC, and also because it's necessitated so since it's a lower middle income country which is struggling, whereby, and also 2.5 million people rely on second-hand apparel imports to earn a living, and therefore will not be proportionate or rather even sustainable to do away with them, in light of pursuing climate change obligations, which may be put in place progressively with time, as it has not contributed majorly to climate change issues. Honorable members of the bench, I would like to seek the floor to my second counsel to continue.
Thank you, Ms. Mune. Perhaps before your co-counsel addresses the court, I will just find out from my colleague judges whether they have any issues they'd want you to clarify. Judge Antoinette Ogange, any issues for counsel to address?
Thank you, Presiding Judge. Probably Counsel Mune, the court would like you to come out a bit more clearly on the measures that have been taken by the state of Azania. How have they met the threshold on necessity and proportionality?
So the state of Azania has met the threshold on proportionality and on first proportionality, in that the measures that have been put in place in the TWCCEA only apply to imports of second-hand apparel, which clearly from the government commissioned audit states that it is this apparel that contributes to the filling of the landfills and the waste, which causes flooding, the informal burning, which causes greenhouse gas emissions, and which eventually will turn and cause climate change. Onto the issue of necessity, it was after the government commissioned audits and that the state saw the necessity of regulating this apparel trade, as failure to do that would maybe in the future would have caused more damage, also under its obligations to do due diligence on their parts. Thank you, Madam President.
Thank you for your response. Thank you, Presiding Judge.
Thank you. Judge Emukule, any issue for counsel to respond to?
None at this stage, Presiding Judge.
Thank you. So we shall move to the next counsel, Madam Shanice.
Much obliged. Madam President, honorable members of the court, may it please the court. Good evening. My name is Shanice Kadenyeka, as earlier introduced by the first counsel, appearing for the state of Azania in this matter. And in the 30 minutes graciously allocated to us by this honorable court, I will take 12 minutes to converse on the fourth merit on digital traceability and extended producer responsibility requirements, merit 5 on the rights of the children and the coastal communities, and merit 6 on social enterprises acting as legitimate actors. I will thereafter render our prayers to this honorable court. If there is no clarification from the bench, I would wish to proceed.
Please proceed, counsel.
Thank you. Much obliged. Members of the bench, picture this.
Just a second. You have 5 minutes left, actually.
Much obliged. Your Excellencies, I will directly move to the fourth issue on whether the digital traceability and EPR requirements constitute to lawful regulatory measures or unlawful discrimination. It is our humble submission that the digital traceability requirements and the EPR, the extended producer responsibility requirements, are lawful and are consistent with international law. I will advance my argument in two limbs. First, that international law poses sovereign authority to states to regulate activities causing environmental harm, and the second limb, that environmental regulation is permissible in trade under international trade law. On the first limb of argument, international law recognizes that states should ensure that activities within their jurisdiction do not interfere or rather cause environmental harm to other states. Article 2.1 of the UN Charter provides that state sovereignty is paramount, and Principle 2 of the Rio Declaration provides that states have a sovereign duty to ensure that the activities within their territory or jurisdiction do not cause environmental harm to other states. This principle was affirmed in the Trail Smelter arbitration case, where the tribunal held that no state has a right to use its territory in a manner that directly causes harm to another state. Also, the ICJ in the pulp mills case in 2010 reaffirmed the principle, confirming that states should ensure that the activities within its jurisdiction do not cause harm to other states, and states must also exercise due diligence in regulating harmful activities affecting the environment. Your Excellencies, if I may invite you to read Part B of the fact pattern, 35 to 45% of the second-hand apparel arrives in the market when it is in unsellable state, most of which is disposed to open dump sites, some of which is burnt, which release toxic emissions to the environment. And this generates microplastic pollution, which contributes to marine contamination and also directly affects the right to the environment. And also directly affects the right to a clean and healthy environment for the citizens of Azania. The Textile Waste Control and Circular Economy Apparel Act and Circular Economy Act was put in place and the TWCCEA was put in place. Sorry for my camera issues. To ensure accountability in the global supply chain of second-hand apparel and overall to promote environmental accountability. It is therefore our humble submission that the Republic of Azania acted within its sovereignty, within its sovereign environmental authority by putting in place the digital traceability measures and the EPR requirements. Turning to my second limb, environmental regulations affecting trade are permissible under international trade law. Environmental protection measures may legitimately limit trade under Article 20B and G of the General Agreement on Tariffs, on the General Agreement on Tariffs and Trade. Sorry for that. The General Agreement, Article 20B and G of the General Agreement on Tariffs and Trade allows measures necessary to protect human, animal, or plant life and conserving exhaustible natural resources to limit trade. This principle was also reaffirmed in the case of United case shrimp rule case, where it was held that environmental regulations affecting trade can be upheld when applied in an undiscriminatory manner. It is therefore our humble submission that the TWCCEA does not discriminate between importers. Instead, it introduces uniform standards requiring quality threshold for traceability, quality threshold for garments, traceability mechanisms, and the producer responsibility for waste management. These measures pursue legitimate environmental objectives. We therefore respectfully submit that the regulatory framework is not discriminatory, but it's fully consistent with international trade law. I will proceed to merit 5.
All right, just a reminder, you have 1 minute left.
I will proceed to the 5th merit on whether continued exposure of children and coastal communities to textile pollution violates international human rights obligations. It is our submission that the failure to regulate such pollution would violate international human rights law. Article 25 of the UDHR, read together with Article 12 of the International Covenant on Economic, Social, and Cultural Rights, provides for the right to attainable standard of health and also the right to a clean environment. In July 2022, the UN General Assembly also adopted a historic resolution declaring access to a clean, healthy, and sustainable environment. Article 24 of the Charter on the Charter.
Kisii University, your time is up.
I would wish to ask the court to give us 2 discretionary means to finalize on our submissions.
And unfortunately, Council, we run on time, and so we will take it that's the end of your arguments.
Much obliged.
Thank you. Judge Ogange, any issue you'd want Council to address or respond to?
None, presiding judge, thank you.
Judge Mukule?
None, presiding judge. Thank you.
Thank you. The court assistant, we may now proceed to hear the responding arguments.
All right, I now invite Lead City University to represent SECA.
May it please this honorable court, I am Marvelous Grace Solomon, and here with me is Adedolapo Ogunwusi. We are representing SECA, the interested stakeholder in this case, and for record purposes, our team code is GLGI 3. And also handling issues 1, 2, and 4. And I'll be using 15 minutes of our time. My co-counsel will be using 12 minutes to make her submissions on issues 3, 4, and 5. And I will come back to use the remaining 3 minutes to say our prayers and relief source. If it pleases the court, I will now commence with my arguments on jurisdiction.
Please proceed.
Thank you. Okay. Article 65, paragraph 1 of the Statute of the International Court of Justice, hereinafter referred to as ICJ, provides that the ICJ may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such a request. Pursuant to Article 96, paragraph 1 of the Charter, the General Assembly may request the International Court of Justice to give an advisory opinion on any legal question. In this present matter, the United Nations General Assembly has requested for an advisory opinion of the ICJ on state obligations relating to circular economy regulations, transboundary textile waste, and climate change. Therefore, the court has jurisdiction to hear this matter. On admissibility, Articles 65, paragraph 1 of the statute of the ICJ, repeated by interpretation of the court, means that the court has a discretionary power to decline to give an advisory opinion, even if the conditions of jurisdiction are met. However, in the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, Advisory Opinion ICJ Report 2019, 1, page 113, paragraph 65, it was stated that only compelling reasons may lead the court to decline to give its opinion in response to a request falling within its jurisdiction. SECA submits and pleads this honorable court that since there are no compelling reasons stopping this matter from being heard, this matter should be seen as admissible before this honorable court. I would now like to proceed to my issues if there are no questions from the bench for me.
Please proceed,
On issue
Counsel.
1. Okay, thank you. On issue 1, whether the ICJ advisory opinion affirms a positive obligation on states to regulate transboundary value chains, including the second-hand apparel trade that contributes to climate change. Your Excellencies, SECA submits that the International Court of Justice, in its advisory opinion on the obligations of states in respect of climate change, delivered in 2025, upheld the obligations of states to regulate transboundary value chains. In paragraph 428, page 122 of this opinion, the court expressly states that states have an obligation to regulate the activities of private actors as a matter of due diligence. Also, in paragraph 132, page 48, where it made mention of customary international laws as applicable laws and highlighted the pulp mills on the river Uruguay, Argentina versus Uruguay, judgment ICJ report 2010, 1, page 56, paragraph 101. It said that states are obligated to use all the means at its disposal in order to avoid activities which take place in its territory or in any area under its jurisdiction, causing significant damage to the environment of another state. Second argument is that the ICJ opinion is an opinion and persuasive in nature, and therefore should not be applied as a binding principle and basis for Tanzania, a sovereign state's action within its territory. Article 11 of the Rio Declaration on Environment and Development, 1992, provides that states shall enact effective environmental legislation and that environmental standards, management objectives, and priorities should reflect the environmental and developmental context to which they apply. African countries like Kenya and South Africa have adopted both environmental and economic rights in their constitution. So it is unsustainable for Tanzania, a sovereign state, to rely on a non-binding international instrument as the basis of fulfilling their obligations to the state. On issue 2, whether Tanzania's failure prior to the TWCCEA to regulate second-hand apparel imports constitutes a breach of the due diligence obligation under international law. Paragraph 428 of the ICJ Advisory Opinion on Climate Change says, and I quote, states have an obligation to regulate the activities of private actors as a matter of due diligence. Before the ICJ opinion on climate change of 2025, Article 24 of the ACHPR recognizes the right of all peoples to a generally satisfactory environment favorable to their development. This was interpreted in the Nigerian case of Social and Economic Rights Action Center, 2001, AHRLR 60, ACHPR 2001, where the African Commission established a state's duty to prevent pollution, control private actors, and protect communities from corporate harm. Tanzania had always had the duty to regulate second ICJ opinion of 2025. So their failure to do so is a breach of due diligence. Also, the Kofu Channel case, United Kingdom versus Albania, Merits, Judgment, ICJ, Report 1949, page 22, established the no harm principle, where every state is to ensure that their activities carried out within their territory does not negatively impact another state. Coffee Channel's case was established in 1949. The African Charter was adopted in 1981 and became legally binding in 1986. This and other relevant legislations, like the United Nations Framework Convention on Climate Change, UNFCCC, adopted in 1992 and entered into force in 1994, have all existed before the ICJ opinion of 2025. So Tanzania's delay to make local legislation regulating the trade in second-hand apparel is a failure to observe due diligence. On issue 4, whether the digital traceability and EPR requirements constitute lawful regulatory measures or unlawful discrimination. Making reference to the landmark case of Waweru versus Republic, 2006, KEHC 3202 KLR, where the court defined discrimination using the Black's Law Dictionary, 11th edition, that discrimination in constitutional law is the effect of a statute or established practice which confers particular privileges on a class arbitrarily selected from a large number of persons, all of whom stand in the same relation to the privileges granted, and between them and those not favored, no reasonable distinction can be found. SECA submits that just as in the case of Waweru and Republic, where it was held to be discrimination, when out of 100 disposal of raw sewage, only 23 were prosecuted and subjected to face penalties. It will also be discriminatory for Tanzania to enforce digital traceability and EPR requirements against informal economic actors, which constitute merely 5.2% of the population. In the case of Waweru versus the Republic, it was held discriminatory when the 23 individuals' rights were violated in order for the state to protect environmental rights. So also in this case, sacrificing economic rights for environmental rights will be highly discriminatory to the parties involved. Please, I would like to know if the bench has any question for me before I cede the floor for my co-counsel.
Thank you, Counsel. Judge Ogange, any issues for Counsel to address?
None, Presiding Judge, thank you.
Judge Mukule, anything for Counsel to
Presiding
address?
Judge, Counsel has none whatsoever at this point.
Thank you so much. Your co-counsel may address us. That is Adelapo Daniela.
If it pleases this honorable court, I would like to commence with my submissions as to issues 3, 5, 6. With the first being whether measures
just hold on, please. Maybe the court assistant can just guide her on how much time she has. Naomi?
She has 20 minutes to go.
Thank you.
With issue 3 being whether measures adopted pursuant to the ICJ advisory opinion may justify limitations on international trade under environmental and human rights exceptions. Answers to this would be no. While environmental protection is legitimate, Tanzania's measures are disproportionate to what is highly expected of a sovereign nation because it is inconsistent and greatly limits trade law. In addition to that, the applicable law that we will be making use of is the World Trade Organization. In the Article 11, it prohibits quantitative restrictions, and in Article 20, it allows but exceptions to arbitrary and unjustifiable and discriminatory stops. Also, it must not be a disguised restriction on trade. The next we have is the ICJ Advisory Opinion of 2025, which recognizes climate obligations, but also requires proportionality, respect to economic and social rights. The principle of proportionality means that it should be necessary. It should be the last means that would be resorted to. From the position of SECA, this restriction on trade, this restriction on the international trade of the people in Tanzania would simply be a hidden motive to restrict the trade generally on the people. This would look like the case of, or the case between the US and the World Trade Organization, with the citation being WT/DS58 and the appellate body report 12 October of 1998. And this case simply shows us that the US was banned from shrimp importation that did not use the turtle protection devices. The World Health Organization simply held that the environmental protection is a legitimate objective under Article 20, but the US's measure was applied in a discriminatory and unjust manner, violating the Charter of Article 20. The SECA makes use of valid environmental goals and becomes unlawful if applied unfairly. Tanzania's regime similarly imposes unequal burdens on smaller and informal traders. The understanding that it is not just big companies that are available or that are existing in big countries. We should also take into consideration and understanding that there are also small businesses that will be held or will be smashed down by this particular law. SECA is trying to say that if for any reason at all there should be a restriction on trade, it should mean that it is the last resort that we are heading toward. It would mean that we have tried everything else. We have tried laws. We have tried different statutes other than restriction on trade, because this would mean that it would be going against the African Charter in Article 15 that suggests that everyone has the right to work. It would also mean that we are going against the United Nations Sustainable Development Goals. That is in SDG number 8, economic growth. Everyone in a country, everyone in the world is or possesses the right to be able to work, possesses the right to grow economically, possesses the right to be able to work and see the profits from their work. But if because of the inability of a country to manage its state, to manage the climate changes, they would be forced to restrict their trade, thereby robbing them of their rights to work, that would be seen as a poorly managed nation. We would proceed to the next, I would like to proceed to the next issue if the Honorable Chair doesn't have a question from me.
Yes, we would prefer that you just carry on, and if we have issues, we'll raise them at the end of your arguments to save you on your time.
On to the next issue, being whether the continued exposure of children and coastal communities to apparel-related pollution violates international human rights obligation, includes intergenerational equity as articulated by the ICJ. With the understanding that we as the world, the United Nations, for example, taking into consideration, is trying to make the world a better place ahead of 2030. Simply what intergenerational equity would go to mean. With the understanding of that, taking into consideration that if climate change continues that way in Tanzania, it would not be a suitable place for the children that are coming in the future. But then again, SECA still tries to say that every child deserves a place where it's comfortable, where they're able to live in peace and not have to think of their next meal. Putting their parents out of jobs, out of work, and out of income would go to mean that the children would not be able to live comfortably. That would also go to mean that it is going in contrast to what the United Nations have decided in SDG 1, that is no poverty. They are trying to eradicate poverty generally from the world. This would mean that every child should be able to live comfortably. No child would be on the road begging. No child would be in their houses thinking of their next meal. And the case law for this would be the Social Economic Rights Action Center versus Nigeria. The Nigerian government failed to prevent oil pollution affecting the Ogoni people. The commission held that this violated rights to health, environment, and life. Now, the violation rose from state inaction, not overregulation. It did not rise because, or the climate change did not worsen because the people of Tanzania were in too much of an economic trade or economic exchange with other people outside the country. It rose because of the neglect from the people making these laws. It did not rise from inactions of the people. Meanwhile, taking into consideration that if the government had given the instruction to them to clear out the clothes or distribute the apparel so it doesn't have to affect the people in a bad way, highly likely there would have been a change. But resulting to this without actually even trying any other options looks like a hidden motive. Another case is that of Fadeyeva versus Russia. A woman lived near a steel plant causing severe pollution, and the court held that environmental harm violated her rights, but also emphasized the need for a fair balance between individual rights and economic interests. This would go to mean that if for other nations, they're taking into consideration their economic rights, what differentiates Tanzania from that? If we're viewing Tanzania as a sovereign state that can make decisions, there is nothing that differentiates Tanzania from Russia, where it cannot take into consideration the economic rights of the people. Other than that, there's also the responsibility that they have to the people to be able to make and grow economically. If not, that would suggest that they are trying to move them into a socialist era, which would be wrong and going against every international law that has ever been made. I would like to also add that most of the time, states make principles, decide on it with the people, the actual people that would be affected by this, but they were in no way showing consideration for the people when they made this law. They were in no way taking into consideration the fact that this would even lead to a bigger issue, that is gross unemployment in their nation. I would like to continue. I would like to continue to the next. Whether social enterprises operating within circular economy models may function as legitimate governance actors in fulfilling states' climate obligation. Now, understanding the previous arguments that I have made in favor of SEPA, we should also not forget that Tanzania is in all the rights trying to make, or Tanzania might claim that they are trying to make a good decision with reference to SDG 13, climate action, where the world is trying to make it a better place by trying to reduce everything that would make the environment bad for the people coming. But let us not also forget that in SDG 11, there should also be sustainable cities. In a city where there is gross unemployment, in a city where there are more people than the people doing well enough, where there's more of the lower class than the middle class, it cannot be a good environment before 2030. Taking that into consideration, we would also look at the ICJ's advisory opinion, that is that the state must regulate private actors and value chains. It implies cooperation as seen with the Paris Agreement, where you can, or they can decide to move forward with other changes that would mean expelling or double checking the products before actually bringing them into their country. This would scrap out the waste. This would scrap out the challenges with the climate changes. And this would also enable everybody living a comfortable life. The environmental law principles is that there would be multiple level governance and public-private partnerships. The case law I would like to use for this is Lopez Austria versus Spain, that states liable for failing to control private pollution. And the application would be that recognizing social enterprises would integrate them into waste management. Tanzania could have also decided to go with waste management, deciding to look for a better way to expel these wastes. If we're talking in respect of examples, I would like everyone to imagine a situation where there is gross plastic in the ocean, and the best way the government sees it fit to expel this waste is by taking everybody out of their jobs, or by telling them that they should shut down the beach, or telling them to shut down the places that actually help the society or the environment look the way it does, or turn down their tourist sites simply because there's plastic in the ocean. They would look for ways to turn that into something else. They would look for ways to make that into something that would profit the entire nation, not just put people out of their jobs. And there's also SDG 17, that's partnerships, SDG 9, innovations. I would like to take everyone on an imaginative ride. That is, imagine a situation where they didn't have to put people out of their jobs. They didn't have to remove people from their day-to-day life, or they didn't have to plunge people into unemployment. And they actually decided to partner with those nations that are bringing in the garments, decide to tell them, hey, why not we give it back to you if you do not like it? If it doesn't come in the shape that we like, or if it doesn't come in the way that we like it, we give it back to you. Partnering with different other people just to make sure that they are comfortable in their nation and they live well. How be it, or how would they explain the fact that they're removing the people, the Tanzanians, from climate change, the possible damage of climate change, and plunging them into unemployment? Like, that's a better option. The next would be that overregulation will definitely harm enterprises, small enterprises, businesses that function mainly because they're little or mainly because they're seasonal will be destroyed because they are out for the greater good, which will generally be wrong. There's also the argument of environmental rights versus economic rights, where we try to figure out which is better, but at the end of the day, we find that both have to come to a consensus. They have to come to an agreement that before we would even want to better our environment, we would have to figure out how everyone could be comfortably, economically. Raising minimum wage in countries or trying to make sure that people find jobs is not just for the sake of it. They don't just do it for the sake of it. They do it because they want their citizens to be comfortable, to live a peaceful life without having the dangers of hunger or poverty, in line with the SDGs.
Reminder, you have 5 minutes left. You have 5 minutes left.
Well, that would go. And if there are no questions, I would like to cede the floor to my co-counsel for our prayers.
Thank you very much, Council. Let me find out from my colleague judges. Judge Ogange, any issues for Council to respond to?
Thank you, Presiding Judge. Council Daniela, the court would like to hear what your view is with regard to the legal threshold of what constitutes a violation. And in this case, the facts before the court, what is it that the state of Azania has done to meet this threshold that amounts to a legal violation?
Well, they did not prioritize it. They prioritized environmental rights over economic rights instead of allowing both to agree or allowing both to come on the same line of prioritization or of significance.
Sorry, your answer is not very clear. Let us start with the first question. What is the threshold for a legal violation?
Oh, the threshold for a legal violation, you mean in line? And I don't think I understand your question quite clearly.
For a state to be held liable, there has to be a violation, yes?
Yeah.
So what is it that is this violation?
Well, it could mean different things, but with reference to what SECA is trying to fight for and what I am defending is the violation against their economic rights, where they should be able to trade freely, except and only if their trade is illegal, should it be enough for them to have to restrict their trade significantly. But it is a violation to put one right over the other, knowing fully well that the other is the reason as to why a lot of people are not on the streets, not on the roads begging for food.
Okay, thank you for your answer. Presiding Judge, thank you.
Thank you, Judge. Judge Mukule, anything for council to respond to?
Yes, Presiding Judge. Senior Council, I'd like your view on the question whether environmental rights vis-a-vis economic rights are mutually exclusive.
Oh, well,
Do you understand my question?
I couldn't hear your question. My co-counsel has told me your question.
The question is this: are environmental rights and economic rights mutually exclusive?
Well, yes, I dare say that they're mutually exclusive.
Why?
Well, because we cannot live in a bad environment. The world in general, no individual can live in a bad environment. The same way no individual can just live without having to work for what they would eat and what they would do. Very, very, very sure that, or understandably, if there is a flooding somewhere, it would definitely put people out of their houses. But the only thing that would save them in the long run is if they have their economic rights, the right to be able to work and earn money. If they have earned enough money, at least they'd be able to build another house for themselves when the flooding puts them out of it. So with that explanation, I think it is exclusive. They're exclusive rights, There's not one over the other.
There is no one greater than the other.
Yes.
In other words, they're mutually supporting each other.
Yes.
Would you agree with that?
Yes.
Thank you. Thanks,
Thank you,
Presiding Judge.
Thank you, Judge Mukule. Ms. Adedolapo, you have raised very interesting arguments, and you seem very fully aware of the SDGs, climate action, and vis-a-vis the economic development. Do you think the principle of necessity fits into any of this? Would it be something that you'd want to perhaps consider? the principle of necessity vis-a-vis economic rights and climate change and climate action. Is that something you think that you'd want to consider in your arguments?
So, do you think the principle of necessity applies to whether environmental rights take precedence over economic rights when there is necessity?
Well, I apologize to the presiding judge, but I could barely hear you, and my co-counsel has.
Okay, I'm sorry, but would you like me to repeat it? Can you hear me now?
Oh, yes, I can.
Okay, I merely remarked that you seem to be big on SDGs. You are fully aware of the different sustainable development goals. And you mentioned the economic SDG. You have mentioned climate action. And my question is, do you think the principle of necessity would fit anywhere in your arguments regarding economic rights vis-a-vis environmental rights?
Well, yes, I do. But in this situation, I would dare argue that there was no necessity. At least there was no necessity yet.
Because
other actions had not been taken. They had not sought other routes on how to greatly reduce climate change in their country. They just thought of one and they went with it.
Thank you, Council. The court assistant, do they still have a little time? Because my understanding was that her co-counsel would wind up with some prayers.
They have 2 minutes left.
Okay. Yes, please proceed, Ms. Solomon.
Yes, ma'am. Your Excellencies, we pray this honorable court to clarify that 1. Tanzania has a binding obligation to regulate transboundary apparel and textile flows, but such regulation must be proportionate and non-discriminatory and must not unduly impair legitimate secular economic actors. 2. Tanzania has due diligence obligations as second-hand apparel and textile waste may constitute transboundary environmental harm, and mismanagement contributes to pollution, public health risk, or climate impacts. 3. Tanzania is required to balance environmental protection with economic, social, and livelihood rights under international laws as articulated in the ICJ Advisory Opinion on Climate Change 2025. And lastly, Tanzania is obligated by international laws to recognize, support, and integrate secular economic actors engaged in the reuse, repair, and resale of second-hand apparel who form part of the climate solution rather than regulate them out of existence. This is our humble prayer. Thank you.
Thank you very much, Council. Court Assistant, are there rebuttals? Naomi, your microphone is off. If you are addressing, then you cannot be heard.
So in case there's any rebuttals from either team, they have 10 minutes for that.
Thank you. So, Council for Azania, Kisii University, any rebuttals?
Yes, Your Honor. So my
that is
lead
university. Let's start with Kisii University. Well, Council
apologies, Your Honor.
Yes, Council for Azania. Kisii University.
With your permission, we'd like to go ahead.
Yes.
Yeah, second council for the respondent made reliance on the different various sustainable development goals. So we are inquiring on the threshold of on the threshold of them being binding or not, And another point from us is from the question that Justice Emukule has posed to the respondents. The second council has responded on the issue on the mutual exclusivity of environmental rights and economic rights. The second council for the respondents has said that none of them is greater than the other and that they are equal, which contradicts their initial position that economic rights take precedence. So we'd appreciate if they if they clarified on their stance. Thank you.
Thank you. Council for lead for SECA. Lead University, Nigeria.
Yes, thank you, honorable judges. I'm so sorry, when you mentioned Kisii, I thought you said Lead City. That was why I replied the other time.
Okay.
I would like to go on with my rebuttals. So I'm going to mention when the opposing counsel created a scenario where she compared a menial job with an internship in a hotel, with a daughter having an internship in a hotel, and said Tanzania seeks the latter. I would like to refute this argument, as this scenario further solidifies my point that Tanzania is being discriminatory towards informal sources of income. Also, on the issue 2, she mentioned that Tanzania had no other option but to prioritize environmental rights over economic rights. And my argument is, why prioritize when both can work hand in hand? I mentioned 2 countries that have adopted environmental and economic rights to their constitution, and Kenya, Section 24 of the Kenyan Constitution provides the right to an environment that is not harmful and that is protected. And sections 26 to 29 provides for the economic and social rights of the Kenyan citizens. Also, sorry, that was for South Africa. For Kenya, it's Article 42 and Article 43 that provides for the right to a clean and healthy environment and their economic and social rights. Sorry for the mix-up. So my argument is that if these 2 countries can decide that both environmental rights and economic rights are both rights that belongs to the citizens and can coexist together, why does Tanzania have to prioritize one over the other? I would also like to mention that we, SECA, submit that before 2026, when Tanzania enacted the TWCCAA, there was no regulation controlling or guiding the disposal of the 35 to 45% of the second-hand apparel that were unsellable. However, in 2026, due to the awakening by the 2025 ICJ advisory opinion, Tanzania thought it wise to enact a highly stringent law, moving from one extreme to another. SECA's position is that we seek for balance. Thank you.
Thank you very much, Council. Sorry, are you still saying something?
No, Your Honor.
Okay, all right. Thank you very much, Council. So we've had your submissions. I think the next step is for the court to retreat to make its decision, but let me allow the court assistant to set out those protocols. Naomi?
Yeah, okay. So I think that marks the end of the submissions for both sides. So I now respectfully request the honorable judges to retire from the public courtroom and proceed to chambers for deliberations. So for the rest of us, kindly remain on the call as we await the return of the honorable judges as they deliver their determination.
Thank you.
Right, judges, we can leave the platform and go to the chambers. Greetings, everyone. We are back from the judges' chambers. And the duty bestowed upon me at this time is to inform the participants of their strengths and weaknesses as assessed by the bench, and thereafter I will give it back to the bench to give its determination. So for Council Angelina Mune from Kisii University, knowledge of the, it has been indicated that you should be more organized in your flow of arguments. It has also been indicated by the bench that you didn't appear to believe in what you were defending. That one could go into preparation. On the positive side, you're a quick thinker and you are not unsettled by the interjections of the court. So you should continue building on those strengths and work on your weaknesses. For your co-counsel, Shanice, the bench indicates you should be more steady. You appeared more tensed. Otherwise, despite those challenges, the bench observed that you appeared focused. For the opposing counsel, Lead City University, beginning with Damilola Solomon, the bench notes that you are well focused and understands the issue at hand. The bench further notes that you have a good grasp of the law and you are passionate in your presentation. What the bench has noted is you should resist the temptation to nudge or to chaperone your co-counsel. You appear like you want to tell her, do this, do that, say this, say that. So the court has observed, like, resist that temptation. So again, it goes to preparation, prepare yourselves well. Otherwise, you are calm, you are clear, you expressed yourself well, and the bench indicates indeed practice will make perfect. To your co-counsel, Daniela, the court indicates you understand international law and legal principles well. You are able to respond on your feet, and your presentation was well researched. And again, practice makes perfect. On my side, I would say, let us avoid the temptation of reading too much. This is for all participants ever since we began. We know it's virtual, we don't see the materials on your table, but try and internalize them, don't read them too much. All right, without much ado, I will give it back to the presiding judge to take over on the penultimate phase. Presiding judge, over to you.
Thank you very much, Dr. Brian. And to the participants, again, thank you for indulging me. Today, technology has just been totally disobedient, but I thank you for bearing with me. We have considered the submissions and the arguments that have been presented before us. We want to congratulate both parties for the research that went into this. We have considered your knowledge of the law, including your understanding of international environmental law and the use of legal principles. We have also taken into account your ability to apply the law to the facts and the depth of your legal reasoning. We have also considered the structure and clarity in your logical flow of arguments and your organization and coherence. Alongside that, we have taken into account your advocacy skills, your ability to persuade the court, your court etiquette, and your responsiveness to judicial questions. And certainly your application of the relevant case law treaties and instruments. And having taken this into consideration, this is the outcome that we have. For Kisii University, that was representing Azania State, you have a total of 67%. And for Lead City University, that was presenting SECA, you have 78%. So Lead City University carries the day with 78%. Thank you. Back to you, Court Assistant.
Thank you very much, Presiding Judge. As the determination has been spelled out, Lead City University take the day with 78%, and Egerton and Kisii University 67%. As we indicated, only the top 8 highest ranking teams will go into the semifinals, into the quarterfinals. Therefore, do not feel like you have lost, because we still have rounds coming ahead. So it's based on the highest ranking teams. Tomorrow's session, same time, preliminary session number 4 between Chuka University, Kenya, and Catholic University of Eastern Africa, Kenya. I believe I've gotten it right. We'll indicate to you shortly the sides you will be representing in your official WhatsApp communication group. Otherwise, as of that, the court is functioned as officio, having delivered its determination in this matter. And if there's no other thing from the bench, then this marks the end of this session, and we are free to leave the platform.